Good evening. Happy Wednesday. I apologize, it's late. I've been fairly busy. Today's been quite a bit more hectic than I like things to be. And I've already had a glass of bourbon, so you'll have to forgive me if I stumble and bumble a little bit through this, but I figured it was fairly important to cover. Not important in the long term, in the grand spectrum of things, but in the ongoing Chillie saga, I thought this was somewhat important to cover. The judge order issued two orders today. There has been no other filings since the motion. The motion to transfer was ECF number 50. This first order is 51. The second order is 52. So Kate and Josh have not filed any responses to any of these things. The judge has just gone ahead and issued orders because these things are fairly easy to deal with based just on what Chillie filed. Now, while these are orders, I want to caution you, at least on the first one, that it is an order, but it's not an order that anybody is going to be held in contempt for. Nothing in here is something that a party is going to move for contempt for, moved an order to show cause for contempt. And I'll explain why. So the first is the order on Chillie's ex parte letter to the court. She ordered, to be clear, the parties are not to destroy or otherwise compromise any evidence relevant to this case. Now, that might sound like it's an order because it's in an electronic order, but it's not, because the difference between what already exists is a federal rule of civil procedure. We've covered this already, but I'll go over it again. It's Federal Rule of Civil Procedure 37, and it is a motion for spoliation. That is down near the bottom. Down near the bottom. Failure to preserve electronically stored information. So this is what we're dealing with here. It's electronically stored information. These are videos, comments on videos. These are what did he think? Text messages, things like that. These are electronically stored information. Now, there is a general rule about spoliation. You can always file a motion for spoliation. It's just one of those stare decisis kinds of things. I'm not going to say common law, but it's a procedural thing that you can do. It's just one of those things that it's so unfair that courts have just a general power to enforce sanctions against spoliation. But for what we're dealing with, there's a federal rule of civil procedure already in place. And that federal rule of civil procedure and just the general rule against spoliation have a mechanism by which you can enforce the or punish, I guess, the spoliation. You can seek to have jury instructions entered that will prejudice the jury against the party that spoliated the evidence, all the way up through having a finding that the evidence that was spoiled or was destroyed, I should say, not spoiled, is found as a matter of law to be negative for the party that destroyed it, that it goes against the party who destroyed its position. So there's a wide range of sanctions already in place, and those are what you're going to use. You're going to file a motion for spoliation. You're not going to file an application for an order to show cause re contempt. The court is not going to do contempt on it. It's going to do spoliation. So this is not anything useful or this isn't a win for Chillie, just so you know. Because again, it's not giving him any new and or better tools to prevent spoliation, if there is in fact any spoliation occurring on Kate or Josh's part. Further, it continues. Further, the court strongly recommends, again, this is not an order, it's just recommending it, that the parties not harass, disparage, or otherwise act unkindly to each other or any potential witnesses in this matter. It is the suggestion of the court that, going forward, when faced with questions of conduct all parties to this litigation and their associates harken back to the lessons they learned in elementary school about getting along with others, proper behavior, and cooperation, and act in accord with those lessons, hopefully without constant recourse to the court. I had explained earlier that one of the things the court is not going to want to do is be the parent for the parties. The court is not going to want to get involved in all the day-to-day bickering between the parties. That's not the role of the court. The role of the court is essentially to make sure the parties are moving along the path towards trial, and then to facilitate the trial. That's the role of the court. Now, in today's day and age, people like to run and tell. People are terrible nowadays because they think that there has to be an adult somewhere who's going to punish the other side. And I see it in my comment sections, and I don't like it. I don't like people who want to run and tell the cops on Chillie because he's filming while he's driving. I don't like people who go and report Chillie's videos. I'm not trying to silence Chillie at all in any way. I am a free speech advocate. I'm a freedom advocate, and I am not a snitch. And I don't like people who do snitch. So if you want to come to me and tell me about how bad Chillie is and expect me to pat you on the back and give you a cookie because you snitched on Chillie to YouTube or to the police or whoever, I mean, I'll mark your comment with a heart and keep reading, or I might even leave a snarky comment, but I don't at all endorse that kind of behavior. And the court isn't there to be the mommy or the daddy. The court doesn't want to deal with all this, petty bickering. And so the court's just saying, look, guys, just fucking deal with it. Just deal with it. You guys go and deal with it. Leave me out of it. That's not my job. That's not my role. That's not what I'm supposed to be doing. I'm a judge who's here to judge the evidence that you guys put on and to render orders on motions and to sustain or deny objections. That's it. Like, that's what the court's there for. So that was the court's response to the ex parte letter. It was a big nothing burger. As far as the judge's order on Chillie's motion to transfer venue, this was a beatdown. This was not good for Chillie. It was denied. It was not only was it denied, but his motion was so lacking in any merit that the court didn't even have to get argument or input from Kate or Josh. The court just denied it without having to hear any opposing argument at all. That's how bad the motion was. And that should really, like, Chillie should learn from that. I don't think Chillie can learn from it, and it's really sad. I don't enjoy Chillie being this stupid. I mean it's fodder for videos. I do enjoy the fact that he gives me something to think about as far as the law is concerned. I like going through the stuff and finding it and seeing where he went wrong and things like that. But I don't want him to stumble through life ignorant and stupid. I really don't. And this should be a wake-up call to Chillie that this is how bad you are. You're getting terrible advice. You don't understand what you're doing, and it's so bad that the court, without argument from opposing counsel, is denying your motions. That's bad, dude. That's real bad. You should stop to take stock of what you're doing because you're on the border of frivolous filings. I actually think it was frivolous, but because you're pro se in federal court, the court's going to give you a lot of leeway. But if you were an attorney, the court might have spanked you a little bit for that. So she goes on to explain the crux of her decision. She says plaintiff chose the venue for this case by filing in this court. Absent the consent of the defendants, the court will not now transfer the case because plaintiff has had a change of heart, as appealing as that option might be. And yes, I posted this in my community section today, and people were noting that the as appealing as that option might be is basically her saying, I don't want to deal with you. And I assume that she's smelling a sovereign citizen because Chillie's filing, his rhetoric, his misunderstanding of the law it smells a lot like what a sovereign citizen does. I mean, it's not the worst thing ever, but it's certainly not good. And I'm sure she would love to get this off her plate. It's much easier to work with a couple competent attorneys who basically know what they're doing. They're going to move the thing along towards the conclusion. They're going to push their clients into getting things settled if at all possible. I mean, it's a lot easier on the court. The court doesn't have to deal with this kind of bullshit up here where the plaintiff, the pro se plaintiff, is sending ex parte letters asking her to do stupid things that are meaningless. So I'm sure she would like to get this off her plate. It's not because she doesn't want to get rid of it. It's because his motion lacked merit entirely. That's why she's keeping it. Not because she wants it, but because he did not meet any of his burden as the moving party to get the motion to transfer granted. She continues, it, of course, remains plaintiff's right to dismiss this case and refile in another district. And that is his right, at least for now. Let's back up out of here. And he has, I believe it is Rule 41. Rule 41. So voluntary dismissal by the plaintiff without a court order. The plaintiff may dismiss an action without a court order by filing, number 1, a notice of dismissal, but notices has to be before the opposing party serves either an answer or a motion for summary judgment, or 2, a stipulation of dismissal signed by all the parties who have appeared. So if he does this before Kate and or Josh file an answer, he could just dismiss it without a court order. If they answer, then he's got to get a court order or a stipulation by all the parties. Now, one of the questions that I've been asked is, well, maybe he will just do that and refile in the central, he'd probably file in LA, which would be the central district of California. But there is a potential issue for him, and that potential issue for him is still in Federal Rule of Civil Procedure 41. It's D, costs of a previously dismissed action. If a plaintiff who previously dismissed an action in any court files an action based on or including the same claim against the same defendant, the court, number 1, it's permissive, not mandatory, may order the plaintiff to pay all or part of the costs of that previous action, and number 2, may stay the proceedings until the plaintiff has complied. Stay the proceedings means that the lawsuit's put on hold. Nothing happens. It just sits there until the plaintiff has paid the costs. Now, as far as what costs are, there is a split of authorities in whether or not costs includes attorney's fees. Costs definitely include filing fees. They definitely include any costs associated with the service of the summons or anything like that. But whether or not it includes attorney's fees, there's a split between the courts. I believe in 2022, just this year, the Ninth Circuit has ruled that it does not include attorney's fees by right. It does not include attorney's fees automatically. There is still a question in the Ninth Circuit. The Ninth Circuit didn't address whether or not it includes attorney's fees if they are awardable by statute, like if the underlying state claim that the plaintiff is suing under, if that has attorney's fees as a possible outcome for the prevailing party. The court didn't say whether or not those could be included as costs. They may be. And the court didn't also refuse to address whether or not bad faith attorney's fees, like if the plaintiff is just being a dick, i.e., doing what Chillie's trying to do, or what Chillie theoretically would be trying to do, dismiss the action in Massachusetts because he lost his motion, and then refile it in the Central District of California, Kate and or Josh might be entitled to. They may be entitled to the costs, and those costs may include bad faith attorney's fees, and the court may stay the proceedings until Chillie pays those, which would really be a nail in Chillie's coffin, because his stated goal, of course, is to run Kate and Josh out of money, and this might flip the script on him, and he might have to pay all of the money that they've spent so far. He might have to reimburse them for. So that would really be bad. Additionally, I don't have any federal rule of civil procedure for this, but personal jurisdiction is still, like I talked about the other day, it's still going to be an issue. There is a very slim chance that California would have personal jurisdiction for this particular matter over Kate. There is almost no possibility that California has personal jurisdiction for this matter over Josh. California has their long arm statute. It extends to the limits of the Constitution, and the analysis I went over it the other day, very, very unlikely that Kate is going to be subject to California's jurisdiction, i.e., very unlikely that Chillie will be able to haul her into court, and she'll just be able to file a 12B2 motion for failure or for lack of personal jurisdiction and get the case dismissed that way. And Josh almost certainly would be able to file a 12B2 motion and get the case dismissed if Chillie files it in California. So that's not really much of a concern. What else did I want to talk about? Oh yeah. So another thing is that someone suggested that that because the right to amend the amendments before trial, a party may amend its pleading once as a matter of course within 21 days after serving it, or if the pleading is one to which a responsive pleading is required, 21 days after service of a responsive pleading, or 21 days after service of a motion under Rule 12B, 12E, or 12F, whichever is earlier. And someone suggested that it might be in the best interest of Kate and or her attorney, or Josh's attorney, to file a answer to the complaint, because then, according to the person who suggested it, Chillie will not have a right to amend his pleading as a matter of course. And I don't believe that's the case. Now, I could kind of understand it, because prior to 2009, an amended complaint, yada yada, Rule 15. This is the current thing. This was last edited in 2021, so you have to be careful of this stuff. But it says it allows the plaintiff to amend their complaint one time within 21 days of serving the original complaint, or at any time before the defendant answers the complaint. And that's not what Rule 15 says, because Rule 15 says that you have 21 days after service of a responsive pleading. So a answer is a pleading, and it is in fact a responsive pleading, and I can prove that. And I could also pull up case law to do it, but I'm just going to show you the sections that the case law relies on. And you can see pleadings. So only these pleadings are allowed. So this is a comprehensive list of pleadings, and you'll notice that an answer to a complaint is a pleading. This is Rule 7A2. So we know it's a pleading, but is it a responsive pleading? And well, that's pretty easy to figure out too. because Rule 12B, every defense to any claim for relief in any pleading must be asserted in the responsive pleading if one is required. So we know that an answer is required, and it's a responsive pleading because this says that every defense to a claim for relief in any pleading, i.e., the claim, must be asserted in the responsive pleading if one is required. An answer is required, and so an answer is a responsive pleading to the complaint. So Rule 15 would still give him 21 days after service of an answer to amend his complaint. So I don't believe that would be the solution that was suggested to me. And there is case law on it. You have to look at district court decisions because I couldn't find any circuit court decisions. It's just so basic that it just never got a circuit court decision on it, at least not that I could find. And so the only other thing that I wanted to discuss was the hearing yesterday. I know that Chillie made a big deal about how he wasn't going to lose, and it was either going to get continued or he was going to win. And that was the Team Skeptic hearing for a civil harassment restraining order in California. Now, Team Skeptic is apparently in Europe, and I was chuckling when I first heard the video that there's no way that Chillie could win, because if Team Skeptic is in fact in Europe, then Chillie's going to have to serve according to the Hague Convention, and the Hague Convention is, well, it's pretty intricate, and every time I've had to do it as an attorney, every time I've had to serve someone overseas, I have just hired a company that does that stuff, because you've got to know who to deal with in the government, et cetera, and it's just not a lot of fun. So I certainly didn't expect that Chillie would have been able to serve Team Skeptic in Europe. And the outcome of that hearing, leads me to believe that Team Skeptic just simply hasn't been served. And the optimism of Chillie that he thought he would actually get the order granted was a bit asinine. There's no way a court is going to grant a 1 year, 2 year, 3 year, up to a 5 year restraining order against someone if they've not been served summons. You're entitled to notice. That's a constitutional issue. You'd think a 20-year constitutional scholar would understand that notice and an opportunity to be heard are constitutional requirements. You can't take someone's liberty away. You have a constitutional liberty interest that is protected by requiring the due process of notice and an opportunity to be heard. You can't lose that liberty interest. Your right to go around in public and be around people, that can't get taken away from you without notice and an opportunity to be heard. And the notice is provided by the summons, and the opportunity to be heard is provided by the hearing. You got to get both of them. You've got to get both of them. The opportunity to be heard. If you don't go to the hearing, the court can rule against you, but you had the opportunity to be heard, right? So Chillie thinking that there was any potential that he could win was naive. Now, I've done a lot of civil harassment restraining orders. It's something that I'm fairly familiar with, and it went exactly as I would anticipate for the first hearing if the petitioner did not have the respondent served. So, what the court almost always does is, at least that first time, the court continues the hearing to a later date. Continue just means that they reschedule it for a later date. They schedule it sometime in the future. That's called continuing a hearing. And then they will typically extend the orders along with that. Now, the court will only do that for good cause shown. And the first time, I've had trouble serving him. Well, that's pretty easy to show good cause. You've only had, usually about 20 or so days, usually less than a month before the hearing is set. So sometimes it can be hard to get someone served in that amount of time, especially considering you're a pro per litigant. He's in California State Court. We call them pro pers in California State Court. So it's pretty easy to show good cause. I haven't had enough time to get him served, yada yada. But that excuse starts to wear thin, and so if Chillie doesn't get him served in a fairly reasonable amount of time, then eventually the court is going to most likely dismiss it without prejudice, which means that Chillie would have to refile it. There's no filing fee on it, but it would. The further away any alleged abuse is in time, the less likely it is the court would grant the temporary restraining order and or the permanent or a extended a restraining order after hearing is what they call it. It's usually a 1 to 5 years, typically around 3. The further back in time the alleged harassment is, the less likely it is the court's going to act on it. So anyway, I think I've babbled long enough. His Team Skeptic deal was just standard procedure for California with a civil harassment restraining order. It was nothing to do with any good arguments on his part or whatever. He had no chance of winning it, at least not until he gets Team Skeptic served. So I hope this has been informative and fun. Thanks for watching, and have a great day.